All right. Well, good afternoon, everyone. My name is Mark Reinhardt, and we have Ryan Rehberg, who's wearing the white shirt and that cool tie, and
Hello,
also
everyone.
my colleague Waylon Poland. Waylon has recently joined the firm. We're really excited to have him on board, and so we are here to talk about a rather strange group of topics, but we are right now in a rather strange time. It's been a time where we've been forced to stay home. We've been told it's phase one or phase 1.5 or phase whatever it is, two. And so that's forced a lot of us to stay home and not get to other things we might want to get to. But I do want to say that thank you very much for being part of this seminar because it's a way for you to learn and to ask questions, to start thinking about your own plan during what's a rather odd time for us all. And as I said but a few minutes ago, there is a way to ask questions on the bottom of my screen. I'm not certain if it's the same for yours, but there is a chat button that should be there. And if you click on that, then I believe you're going to have an opportunity, if you want to ask questions throughout. We'll probably try to get to those as we see them, but if not, I'll stop about halfway in and answer the ones that I can, and then Ryan will carry on and he will answer questions toward the end. So today's session is really going to be about, first of all, what do we do right now if we're at home and we can't get out, or what can we do quickly, and our phrasing of how do we prepare to die. We did a very similar session on this about a month or so ago, and a lot of the questions had to do with, okay, well, do you have some time to tell me about the different tools that are available? And so we thought for this seminar, we would go ahead and try to talk a little bit about what you can do immediately, but then also in part two, talk about what tools would be available for you. What's out there? What kind of tools could you choose, whether it's a will or a power of attorney or anything like that? So in this seminar, you are going to see, right, we start out with, how do I prepare to die, which I'll mostly be covering, and then what tools are available, which Ryan will be talking about. And then I picked a few quotes out here, which I love this one by Annie Lennox at the beginning about how dying is easy, it's living that scares me to death. Our goal today is very much to make sure that at the end of this, not only do you get information, but also you get resources and you have an action plan of what you can do. And so those are kind of the goals we have, as well as answering questions you might have, or maybe even just giving out, credible information instead of maybe the myths or half-truths that you've heard or maybe misunderstood from other sources. So the basic parts are going to be, how do I prepare to die? And that'll be broken down to what you can do immediately, how to get others to be able to help you quickly. Of course, we want to be sure we don't do the wrong things. And then if we get an unexpected reprieve, there's more time available to us. Then what could we do? Which leads pretty well into what tools are available, because the unexpected reprieve is very much going to be about what kinds of things could you take action on, whether it's a estate plan or revising your will, making sure your trust is up to date, things like that. So next slide, please. And that is part one, prepare to die. So when we think about this, the idea especially is when you're at a seminar like this, the basic plan is, oh, okay, you need to do this and you need to do that and you need to take action on this. But the main thing is, if we were really in this kind of situation, and regrettably, there have been a number of our clients during this time of COVID-19 who have been in this situation, be sure that you are, taking care of yourself and family and friends and faith or other things that are important to you. All of these things that then we'll move on to, those are kind of fundamentals for you to say, okay, I've taken care of these legal issues and these titling issues and other things. Therefore, you do have more time. It's not uncommon for us to hear at the end of a meeting that, wow, it took me a long time to get to this mark, or Ryan, I couldn't get to this for a while. I'm so glad it's finally done, because now I don't have to worry about it. I can focus on the other things that are really important in my life. The first kind of issue then is if you are aware something's going on, if you don't have a plan at all. You've found the seminar and you're thinking, uh-oh, I know I should be doing something, but I don't want to wait any longer. Oddly enough, this is a good time to update, because you have time to think about it. You have time to deal with it. And, there's more opportunities to reach out than you may normally have when everybody's busy, you're busy, everything's going on. The other thing is, if you just haven't looked at your plan in a while, it's not uncommon for someone to reach out to me and say, Mark, I want to look at my plan, but, it's been a few years. And then the file comes and I take a look at the file, and turns out they haven't been to see us in maybe 15 years or 20 years, or maybe Ryan's dad, Hugh Rehberg, did their initial plan in the mid 90s or early 90s, and they never, updated it since. So the first thing is, if you haven't got a plan or you haven't updated in a while, you can take some action pretty quickly if necessary. The first thing is going to be pretty straightforward. Remember that in most cases, your will or your power of attorney, your living trust, those are going to cover certain types of assets. If you die, some types of assets will transfer by their terms. And those assets may be things like an IRA or an insurance account. It might be a bank account, things that have a beneficiary designation on it. So you said, if I die, then my primary beneficiary is my spouse. If they're gone as well, then my contingent beneficiaries are my kids. Those things you can take action pretty quickly, because you're reaching out to that IRA institution or the bank, and you are, filling out some paperwork, but you don't have to wait too long, or going online and making sure that your beneficiary designations are set. I unfortunately right now have two situations, two estates where people didn't get to this. Husband died and then wife got the IRA. She never added any more beneficiary designations. Then she died, and now unfortunately the IRA is going to the estate. And there are some tax and other reasons that we wouldn't like that to happen. And I've also got one where, for whatever reason, someone put their estate as the beneficiary on their IRA, and there too, that can cause some problems. So remember, we're here as a resource. If you do have questions, reach out on those things, but you can take care of those things pretty quickly. If you're married and you're realizing, wow, I just got a very bad diagnosis and I don't have long, there are a few documents that you could put together pretty quickly. The first of them is going to be a community property agreement. Ryan will talk a bit more about this in a few minutes, but the basic plan is this would give everything to the surviving spouse for Washington property and could be put together pretty quickly. And so that way, if something happens, we've met with people where we literally know someone maybe has days or weeks to live, and we're able to at least make sure that things can go to the surviving spouse with a relative minimum of, cost and bother and effort. Wills can also be put together relatively quickly, a last will and testament. Ryan will also talk about this in a little more detail. This essentially, a will says, here's who's in charge, that would be the executor. Then here's where things go, and it can also say how. So a will can kind of handle your estate and your durable powers of attorney. You want one both for healthcare and also a financial or durable power of attorney for tax, legal, financial. Again, you really want to try to make sure those things have been done within the last 5 years or so. And then finally, there's a directive to physicians. That is this end of life document that really gives people an idea of what you want and tells the doctors, here's what I want if there really is no hope. Do I want everything done, heroic measures, the works, or do I say, I really, if that's the case, make me comfortable, but otherwise let me go? All of those things Ryan will talk about in a little more detail. So let's move on to the next slide. Now, here's where things get interesting. Many times I'll meet with clients and they've sort of forgotten that they got an estate planning notebook from us. Da, da, da. So here's the estate planning notebook. And you'll notice it has our name on it, Rehberg Law Group. If you have one that maybe has our former name, Albertson Law Group, on it, or you have Albertson Rehberg, or you have some other name, it may be time, actually, good way to decide, maybe I need to come in, because we've had this name now for quite some time since Ryan took back the firm in I think 2012. So you want to let everybody know where your estate planning notebook is located in your house. That's a really simple thing you can do, because your original document should be in here. You're going to open this up and you're going to find different tabs, and it'll have a tab for a will or a trust or things like that. And the basic thing is, if they know where it is, you're going to say, look, if something happens to me, I want you to just go find the notebook, and that will tell you what you need to do. The other thing is, there's some parts of your notebook that you should write in. Now, don't write on anything that has a notary stamp with that document, essentially your will or your living trust, your powers of attorney, your directive. Don't write on those. Don't say, well, I want my daughter out, so I'll just scratch her name out. That will cause problems or confusion. But there are many places in this binder where if you write down things, it will really help people down the road. There's a tab in here toward the back under information, and it's who to contact. Who are the important people if something happens to you, if you die? So not just our names and contact information. We're, of course, very shy. We've got our name everywhere. But also, maybe there's financial planner, or there's insurance, or you have a burial plan. Things that will let people know, wait a minute, here's where I can give get a start if something happens. Of course, there's also pages for where to contact family members. I recently met with a family, and they have family members spread out literally all over the world. And if something happens to them, their executor is going to have a hard time knowing where everybody is. They actually have some people in Switzerland, and Ryan and I can both assure you it is not easy to contact people overseas if they don't want to be contacted, or we don't have good information for them. You may have digital accounts and assets, things that you have where you've got different photos or family documents that you've uploaded to the cloud. Different kinds of passwords for different accounts. Your documents, as long as you've updated them in the past 20 years or so, or at least in the past 5, they should have something on digital accounts. Washington State has a Digital Account Act, for example. So all of those things, you can write down what it is. Some people, they feel uncomfortable about putting all that information in the notebook, but they can at least let people know where they have those digital accounts and passwords. So if something happens, they can get a hold of it and start finding out where the information is. Many of us these days get electronic statements, so people may not even know where the account is and how to get a hold of it and how much is there, unless they're able to have access to those accounts down the road. There's a place in your binder as well under the other information that is for biographical information. This is, the kinds of questions that someone would ask if you die, and they need that for your death certificate. It's a little creepy, especially right now with COVID-19, to fill in that, but you're going to know these items. You'll know this information, and other people may not. And if they guess wrong, they forgot, how many years you went to school, or your exact birthday, or your middle name, it can actually cause a few weeks delay, because correcting a incorrect death certificate takes a few weeks in most cases. So you could put that information down right now. Then in the back of the binder, there's also something for burial and funeral arrangements and wishes, so that if you want a certain kind of service or you want to make sure that people know. I had a client whose mom wanted to be buried in or her ashes sort of scattered in a park in Scotland. I've had people, who have specific desires, but if the family doesn't know, especially if it might cost money to make this happen, suddenly people can start arguing. And so you want to first use your estate planning notebook as a way to help other people help you. That's a great one-stop shop for you. Most of you, by the way, are going to have a document in your binder called a memorandum. And the memorandum is often in the front of the binder. More recently, we've been putting it under the Assets tab. But about 3 or 4 pages in that memorandum, as you're starting to wonder, how should I title this account or this asset? There are some good general rules of thumb for different types of assets and how you may want to title those kinds of assets. And of course, if you have questions, it's a quick question or something like that, or an email, we're happy to answer those. And typically don't bill for something when it's a really quick question. All right, next slide, please. So let's think about, we talked about what we should do. There are regrettably a number of things that we just shouldn't do. And what I often will meet with people, and they're in a hurry because something has happened, then they say, well, Mark, why can't I just go online? Or my brother got a will from a book that he got, and I'll just copy what he did. The basic idea with any of this is you need to be really careful if you're trying to do your plan yourself. Ryan has a great analogy. He compares it to trying to build an airplane yourself and then letting your family fly it for the first time. Because any mistakes that you make, you aren't going to be around to fix them. And no one is going to be able to answer or ask you, what is it you actually meant when you made that mistake? So that if you put the wrong name in, or you didn't quite understand what a certain phrase meant or a certain word, and you make a mistake, your will says what it says, and people are kind of stuck with that without going through potentially a lot of additional cost and headache and bother, or even litigation. I've had people make simple mistakes like they forgot to have witnesses, or they had witnesses who were members of their family. That's a no-no. Or they just didn't understand what remainder meant. I had a client who came in, and fortunately still living, but they had done a do-it-yourself plan, and they gave all of their personal effects to spouse, and then kids, and then parents, and then if parents were gone, then brothers and sisters, and this went on for a page or two. Well, personal effects are the things that aren't nailed down in the house or the garage. So there's stuff inside the house. They made sure that nobody was going to argue where things went. But then they had a phrase that they didn't quite understand. It was the remainder or the residue. And they said, well, the residue goes to these second cousins once removed or something like that. What they didn't quite understand was residue meant everything except the personal effects. So if husband died, the wife got everything inside the house, but under husband's will, the house itself, or at least the husband's part of it, was going to second cousins because that was the remainder. So I would say be extremely cautious about trying to do it yourself. One of our former attorneys, Mark Albertson, used to say, people don't pay us for the documents. They pay us to make sure things are done right. That's the real key when you're hiring an attorney. So you can make that mistake with the do-it-yourself plan or the signing formalities. That's making sure the right places are signed and the right people are signing them, whether a notary or an independent witness. People will often, unfortunately, make mistakes with titling, where they're just trying to hurry up and do things in a hurry. If you have the wrong people, or you just say, I'll just give this to my daughter and add her to my account as a joint with right of survivorship because I'm in a hurry and I want to make sure this doesn't go through probate, then when you die, if it's joint with right of survivorship, it's hers. And then she's going to have some trouble trying to give that to her siblings, let's say, your kids, in the shares you thought. Because remember, you're titling, if you title documents in certain ways, they don't pass under your will. And of course, that's if daughter wants to give the assets to her siblings, but she may not want to, or she may be in the middle of a divorce or a lawsuit and she's not able to give those items away. If you're giving away part of your home, be very, very careful. Just adding somebody to the title on your house, that is a gift right now. And so just retitling it can often mean gifting. One of the things with gifting that can be really dangerous is you give it haphazardly, or you give it away and you did it right, but you forgot. Things get what's called a fresh start in basis when you die. That means that if you bought your home for, let's say, 200,000, but it's now worth 800,000, if you give it away during life, your daughter has 200,000 in basis. Then she sells it. She has a $600,000 capital gain. If you left the house in your estate and it gets a fresh start in basis, then the basis value is now 800,000, your date of death value. It's sold and there's no capital gain. So making mistakes with gifting can be an issue too. If you give away more than $15,000 per person per year, be aware that you also may need to have a filing that's done with the IRS called a Form 709. Now, the last one is pretty obvious that since you're all here, you're probably not going to do, and that is nothing. But it can be easy, especially during this time, to just get overwhelmed and just kind of slowly let things take their course. And I will unfortunately tell you that is a bad plan, because often doing nothing means things are really in a mess. I was talking with someone earlier this week, and they mentioned that nothing had been done in an estate plan. Surviving spouse, it took them about a year just to try to figure out what was going on, because the husband had been kind of the one doing everything, all the financials. So it's really a better plan to get all of this taken care of right now. The next question, or the next slide, please. Well, suppose we're not facing death in a couple weeks, right? What could we do? Well, the first thing to know is most of our planning right now, we're doing by phone, we're doing by these sorts of Zoom conferences. The bad news is we lose the personal touch. The good news, of course, is you're not having to get in your car and mask up and come on up to our offices for that initial meeting or two. And we can get almost everything done. We're very much trying to make sure we have our masks and we've got those, everybody's wearing them when we're with anyone else. And we're trying to keep 6 feet distances even when we do meet. We're wiping everything down as much as possible. We've got glass between most of our staff and each other, and certainly between our clients and our front desk. So when you do come in for something like the signing, don't be alarmed. We're doing everything we can to keep everybody as safe as we can. So if you can get that kind of reprieve, then Ryan will talk a little bit more about this, but that gives us some other opportunities. If you have a will or you have no planning at all, be aware that in all likelihood, there'll be a probate when you die. And if we have more time, Ryan will talk a little bit about how we can use a living trust to have, avoid that probate. That can be especially critical if you have property in more than one state, because that might mean more than one probate in each state. If there's an estate tax issue, remember the estate taxes are still around even during COVID-19. Washington State, there's an exemption, consider that a limbo bar. Anything under that limbo bar is not taxed, but that limbo bar is only 2.193 million. Anything above that is taxed to 10 to 20%. So we can plan around that with enough time. By the way, I should mention the federal level is currently sky high. The exemption is 11.58 million. But beware, that number is scheduled to come down by itself in just a few years. 2026, it'll be about half that amount. And of course, we've got an election or two in between, and you may want to go on the candidates' websites and take a look as to what each one would like. Right now, Joe Biden's campaign has said they would like the exemption to go down to what it was during the Obama administration. So either 3.5 million, anything above that would be taxed, or maybe a 5 or so. It kind of depends on what they might be successful with. But if there's time, there could be planning to make sure that we can take advantage of whatever exemptions are available, whatever legal tools are available to reduce that estate tax on other people. Finally, if there is maybe a rental home, or maybe there's some other business that you're working with and there's sort of an asset protection concern, what if somebody sues, they go onto the property and get hurt, then an LLC, a limited liability company, might be available. Would that be something to look into? And for some people, an irrevocable trust. Ryan will talk about revocable living trusts. Those you can change and amend or even revoke if you want to. And irrevocable trusts are also tools that are available if we have more time. Those not only can provide additional asset protection for you and your loved ones, but also some estate planning protection as well. All right, next slide, please. So let's talk a little bit very quickly about a checklist. If I'm at a meeting and I'm writing furiously, it always is helpful if at the end of the meeting I write, here's what I need to do. So number one, when you get off this call today, check the titling on your accounts, especially if you have a living trust. You want to make sure things are titled appropriately. And if you have the memorandum in your notebook, that'll help you. But mostly you want to just make sure that that there's beneficiary designations. Those are the people that you want. You've filled out primary beneficiary, and try to double check and make sure you remember or you have contingent beneficiary designations as well. You can also and should review your current estate plan, because you may find things are different now. Either people are different, or if they're more than about 5 years old, the laws have changed significantly in a number of ways. But your will, your direct dispositions, your powers of attorney, you want to just take a look at those. The law doesn't change by itself. It happens over time, but probably the people in your world have changed as well. And so it may be there's just other people you would like to have serve in different places, or how you'd like to give them the money, that kind of things. Remember, you want to update that information and provide it to your loved ones in your notebook. Let them know where it is. And then I'll tell you, now's a great time to be able to meet with your attorney by phone or Zoom call or an in-person meeting. We're happy to do that as well. Most of the signings we're doing are in person, masked up, having the white tables and pens, making sure everybody's safe. So those are the kinds of things you can do very, very quickly and get everything as fully up to date as possible with as short a time as possible. If there are any questions, I don't see any yet. And Waylon, do you see any? Oh, 2 participants raised hand. All right, well, we're going to try to figure out how to make that work when you raise your hand and before the end. So at this point, thank you. If you do have questions, I'll go down and see with Waylon how we can try to make sure you're answered. And in the meantime, I will turn it over to my colleague and partner and friend, Ryan Rehberg.
Hello, everybody. Welcome aboard. Part 2 is what tools are available. Several of these. Oh, Mark, there's your question down below. If sole survivor living in senior home, how do it went away, Waylon? How do we ensure proper care or on-site advocacy?
That's a very difficult question right now because most senior homes aren't allowing people access, or many of them are not. There are definitely ways to try to see if you can link in through any kind of Zoom call or anything like that, but you're probably going to try to need to talk to the on-site people and have them coordinate that right now. I have been able to visit, but those visits are pretty limited at the moment. But you may want to try to reach out to the home and see if they'll allow you to talk through a window or maybe through a door, or they'll even allow a call. Many of them are loosening the restrictions somewhat. But I will tell you, that's a great question, and right now it is difficult. Of course, if you are able to talk to them or things like that, you want to make sure that they know you're the power of attorney or how you are available this. So, all right. So it goes on to say, assume post-COVID, I am concerned about elder abuse. So here it's a question of making sure you're visiting, and there are different kinds of people that you can, a care coordinator you can engage as well. And that way you can have someone who is you've engaged to make sure that they are, checking in on a parent or a loved one. Next question, will we have access to any of this info? We are taping this. I do apologize. You don't have to write furiously or angrily or fast, but it is something that, we are going to tape this, and I believe it'll be available. You're going to see at the ending slide, the last slide in this, there is a link to our website, and it shows you where to go on our website for our seminars. And probably in a week or so, this is going to be available on that, and you can, take a look at it again. But I'd encourage you to also consider looking at some of the other seminars as well. There's a couple mini seminars, a few of them that Ryan and Jim Davies and I have done. Those are maybe 5-10 minutes about basic topics, but there are also some longer ones as well. All right. Thank you very much. I will turn it over to Ryan. Great questions, everybody.
Bonnie, I will also answer the question with regard to information. Hopefully, you did receive an email that would have the handout that we're using today. If for some reason, check your junk mail. If it still didn't come through, please do give a call in afterwards so that we can make sure that you do get a copy. So the handouts themselves, you're going to get a copy if you have not already. You're more than welcome to one. Next question. Good afternoon, team. In addition to have the living trust done, do we need to buy funeral plans from a funeral company such as Neptune Society? That is a personal preference. I have a lot of clients who actually like doing that because they want to make sure they prepay for what they are wanting to have happen. I can tell you that if you do prepay and you're a client of ours, you have a place in your notebook to put the information. If you're not a client of ours, please tell those near you where you are keeping the information. Do not be the family who came to us after the fact. Their mother, they were sure, did a prepaid plan. They could not find it. Turns out they eventually found it in a shoebox, in the coat closet, in the back corner under the boots. Why? The problem was they also found it several weeks after mom had passed away and after they'd already done with mom what they wished to do with mom. So if you do a prepaid plan, please, please, please make sure those nearest you know where to find it. Additionally, remember, in Washington State, the default is still to bury you. If you want cremation, aquamation, or the third one, which I can never remember, check our newsletters, then you definitely need to have that in writing. You need to coordinate that ahead of time. Okay, we're going to go ahead now and look at what tools are available. Again, at the end of this time, there will be time for you to ask more questions. So we will definitely get to those. What I'd like to look at, and some of these are tools that Mark has already referenced, we're going to have some fun with them. So we'll talk about a bit about who carries out the plan, a will or a trust, powers of attorney, financial and healthcare, estate tax planning. People are concerned about that or not concerned about that. Be aware that in October, we are going to have our next seminar. That seminar is, are you prepared for the results of the election? that both parties are talking about what they choose to do with estate taxes if they are elected or re-elected. So make sure that you tune into our newsletters and get updated on when that next seminar will be. Even at that, remember there's a difference between the state of Washington and the federal government, and those are all being toyed with. Assets, property, title, we talked a little about that. We got some good stories there. And last but not least, please unplug me. So next slide. Let's talk about titling. First of all, be aware that titling has caused a lot of problems. It is a very good tool in very limited circumstances, but a couple issues become important. One, everybody must guarantee that they will die in the right order. Because if you don't, then any beneficiary designations you have may not work. Couple of horror stories. One of them was a situation where mom had one son who was here paying bills. It was a good son, kept under 10,000. All that was happening with the bank account. But right before mom passed away, she was in the hospital for a while, did not realize that a CD came due of a little under $100,000. When mom passed away, the joint account with that son was a little under 100,000. Problem is, there were 3 kids, and that money all belonged to the son. So be aware, joint bank accounts are good if you want it to go to that person. And if you do want it to go to that person, make sure if they're not alive, you put a secondary. POD, TOD, payable on death, transfer on death. Those are more involved with security accounts. Those are more involved with people who have stocks or bonds where they're trying to deal with those issues versus a bank account. Again, they work really, really well. Many times we'll come across clients who had a lot of bonds. The problem is when they die, they actually had put someone on as a beneficiary, transfer on death to this person, but what if that person's dead? Now we have another problem as to where does it go? You also have to make sure that the people you have, you still like by the time you die. It's sometimes awkward to go ahead and change those, especially on a deed, transfer on death deed, because they have to sign off. Life insurance. Life insurance is a good tool, except when it doesn't work. Again, a case that came to us where a husband and wife, actually that was on the IRA, the life insurance went to a spouse, but that spouse had already died. So with that life insurance going to that spouse, now all of a sudden, when the family had tried to avoid probate, that money was being paid out to the estate. And being paid to an estate of someone who'd already passed away years before doesn't work as effectively as you'd like it to work out. Again, depending on the estate plan you have on all of these, the estate planning attorney, the financial planner, the CPA, your 3-legged stool, will work together to make sure all of these go in the same pattern you would like to have happen for your estate planning. IRAs, 401ks. This was the situation of the husband and wife. Common car accident. Kids are the secondary beneficiary. Husband died immediately. Wife was in a coma for 3 months. Wife passed away after 3 months. The children who were the secondary beneficiary contacted the company, said we'd like to roll over mom's IRA. The company said, that won't work. Why? Dad died first. The IRA belonged to mom. So they just told the family, your mom didn't come in and update her beneficiary designations. The kid said, mom was in a coma for 3 months. How would she have done that? And the institution did not have an answer for her. The only response by the institution was, in this case, we will pay it out to the estate, unless you want to get a court order. Be aware, you want to check with any institution if you have a beneficiary designation and ask them, what would happen if people die in the wrong order? Pensions. One item about a pension is that for most people, When they choose to receive their pension, they will choose a surviving spouse or just their lifetime. The majority of pensions do not have a beneficiary designation on them. On the few rare pensions that do, please make sure you have put a proper beneficiary designation on those pensions, but it is rare. Keep that in mind. Another caution, if you're a husband and wife and you're using only beneficiary designations and you appoint each other, make sure you never travel together anywhere. Because if you die together, who gets it next? So again, it's a good opportunity, if you have not looked at these in a while, to meet with your attorney, to meet with your financial planner, to make sure that all beneficiary designations that you have match up with what you would like to have happen in your estate planning. We do a complete another seminar on what happens if it's a death or a divorce and how to update your your beneficiary designations. But that's again a situation, if you've been through a major life event, a death, a divorce, a fracture in your family, that's another good time to make sure you're reviewing your beneficiary designations. So another set of the tools are the powers of attorney. The first one we'll look at is your financial power of attorney. This is the person who can stand in your shoes. They can do tax returns, they can do banking for you, they can go to the post office, they can rob you blind. Make sure you choose carefully who you put in charge. First issue is make sure they're well drafted. Who is the backup? Those of our clients know we will end up asking for 2 or 3 backups to the primary person. Why? Because you can't guarantee us who's going to be alive and who's not going to be alive. Having them well drafted also means they should not be 1 paragraph long. In the state of Washington, there's a full statute on your powers of attorney, and most institutions want pieces of that statute in the document. You should also say, does it become effective the minute you sign it, or only if you become incapacitated? Double check. We've had a lot of husbands and wives come into us, used the power of attorney, or at least had the power of attorney to each other, and I quickly explained to them that's illegal, because for some reason they were given a power of attorney that would only take place if the other is incapacitated. So keep in mind, and remember, please, powers of attorney pass away when you pass away. 2, power of attorney shouldn't be too old. How old is too old? Well, technically by law, no age is too old. Any power of attorney should work. The predicament is institutions have been sued too many times because someone came in with a power of attorney and yet it was old enough that a newer one had been done to someone else. And that was someone coming in to enact fraud. In those cases, institutions are saying if it is too old, whatever that means to them, they'd like you to do a new one. Another issue is, just because you gave someone else the power of attorney doesn't mean you lose any control. You can still mismanage your own assets any way you'd like to. It's your money. Last but not least, a financial power of, well, not last, one more. The financial power of attorney will in there say that if you need to have a guardianship, this is who you'd like to have be the guardian. It does not set the guardianship up, and it does not avoid it. It allows that if it's needed, someone's designated. Last point not on here, just something I want to remind you. If in fact you have minor children, most people put their guardianship for their minor children in their will. But a will is only death planning. What if you're in a car accident and incapacitated? Who is the authority to take care of your children? Please make sure that if you have minor children, or if you have minor grandchildren that you watch, that the parent gets a financial power of attorney and appoints in there a temporary guardian for any minors. So someone has the ability to take care of them if the parent is incapacitated or unavailable. Next slide. Healthcare. This is the issue of you're unconscious. You're at the hospital, your arm's crushed, maybe a leg's crushed. We have to figure out, are we going to try to rescue it or are we going to amputate it? You're in the middle of surgery, something goes wrong. What type of medicines? Anytime you can't answer for yourself, this is the person who is to answer for you. They're the surrogate, they make the decisions. If you can't say it, they do. One of the things to be cautious of here is, again, point of backup, make sure it's not too old, but give very clear, careful instructions. Occasionally, we still see a power of attorney for finances that has one paragraph regarding medical. We actually put two different documents together. One is financial, one is medical. I want the penny pincher in the financial. I want the empathetic person in the medical. Backups, put them in there. Make sure you have someone in there who has your best interest at heart. Keep in mind also that the healthcare power of attorney is the one who eventually will bring out the next document. So that's called the living will. This is someone that you appoint. You must make sure they agree with your desires. If your desires are to be unplugged, they're the one that will bring that out. If they do not want to unplug you no matter what, they shouldn't be the power of attorney. The other person we joke about that should not be appointed is, of course, the person whose first question is, am I in the will? Because then you know they'll unplug you really, really fast. So be cautious on that. Powers of attorney end when you end. If you are the power of attorney for someone, please remember, if they pass away, other than disposal of remains, your powers are gone. It is the other documents after your death that will then control. Next order. Directive to physician. This is your expressing your wishes not to maintain on life support systems. The caution is, if you do not have this document, in front of you is the statute of who will be doing that decision for you. Yes, they'll have to get a court order, but it may not be that you want your parents in control, your spouse in control. It may not want your adult children next. And then your parents? What about siblings? Next closest relative, friend or significant other. All of those are the order, one after the other, as to who is going to be the one that will make the decision to unplug you or not unplug you if you don't have this document. So these three, financial power of attorney, healthcare power of attorney, directive to physician, we call these the incapacity documents. Very important for anybody over the age of 18 to have these three documents. So Mark briefly talked about a community property agreement. Let's go there. This is a contract. It is saying in Washington that everything you have had, do have, will have, is going to be characterized as community property. But if you're asking, wait a second, we live in Washington State. Aren't we a community property state? Doesn't that mean that everything I have goes to my spouse? That's not the case. Yes, we are a community property state. There are several community property states. Only about 2.5 states will allow a transfer of assets based on this document. In Washington, you are entitled to give your separate property, yes, there is still separate property, and your half of the community property to whoever you want to. This document in Washington shows that you want it to go to your spouse, and if you die, it can go to them without court involvement in a probate. In Washington, there is separate property, inheritances, things gifted to you, award settlements from some lawsuits, and things you bring into the marriage. If you have a wedding ring, remember back to when you got married. When did they give you that wedding ring? If it was at your wedding, my question to you is, was it before or after you said, I do? If it was before, you brought it into the wedding. it's your separate property. Do not let your spouse add other jewelry to this ring. They're commingling it. Then it's part theirs. Tell them, you got 9 other fingers. Give you more rings. But in Washington, if you want everything to go to your surviving spouse at your death outright, a community property agreement is a very important document. It is also very helpful for people who move to Washington that are from states that are not community property states, because it can help with the state tax issues. Again, that's a question where you will want to work with your estate planning attorney, financial planner, and CPA to discuss those issues. Let's talk about a will. Your will is a document that says who's going to receive things, who's in control, who are my beneficiaries, and when do my beneficiaries get their inheritance. It is you putting in the formalities of Washington. And Mark talked about this, that sometimes people have gotten wills that do not meet all the formalities. In that case, the will is no good. So working with a reputable estate planning attorney that knows the formalities and can do the document for you is very, very important. As to who receives it and who's in control, you pick not only who is going to get it, but when. We do a complete seminar on, can you control from the grave? Yes, you can. You absolutely can. And if that's a seminar you'd like to come to, let us know. We'll do that on one of our next ones. In most cases, depending on the ages of the beneficiaries, it may be that you hold it for them for a period of time. Certainly, if there's anybody under the age of 25. In doing this and holding it for them, you get protections. Protection from their creditors. Protection from someone who wants to marry them for the money. Protection from estate taxes. And last, protection from future beneficiaries. The example I use is my own family. I have 2 boys, 29, 26. If Sandy and I both died, do Alex and Adam receive their money outright? No, they're 29 and 26. We even have a 10-and-a-half-year-old grandson. Our son asked us to hold his share in trust till he's about 60, so that if we both died, Alex received the inheritance, no one will be able to come and marry Alex and take the money away from Caden. Wise decision. There are many reasons why a person will put protections in place. But in putting the protections is because you want control after you die. Remember, an inheritance is a privilege, not a right. It is your money, and you can choose who gets it, how they get it, when they get it. Another very important thing is, who do you choose to serve as your personal representative? This same set of categories applies to your powers of attorney, both financial and medical. There's 4 main categories. Category 1, your kids. If you have children, if they're adults, if they're mature, if they have the time, if they agree with your decisions, they could be in charge. If you can't say yes to all of that, and that they're available for 350 to 700 hours after you die, pick someone else. Extended family. Might be your parents, might be your siblings, might be cousins, might be aunts and uncles. Who do you want to put in charge that is extended family? Third, best friends. These are ones you wish were family. Last but not least is professionals or corporate trustees. Always begin with family, then immediate extended friends, and then corporate. Why? Because gradually we are all more expensive. We are the most expensive. Why? It's our job. We're held to the highest standard. We have more to lose if we mess it up. So choose carefully who you want to serve. And like your powers of attorney, remember that you want to put backups. Certainly if you're married, your spouse, but then you'd have 3 more. If you're not married, then just pick 3. You also can put people together. We have situations where the family wants all 3 of their kids to have an equal say in the decision. Great. Then make them unanimous and put them all 3 together. We have clients who want to say, let them make a majority. Good. Then make a majority. We also have those that trust implicitly their people, so they go and said, or all of you decide. Any one of you can make the decisions. Come in and join in and be a part of it. So choose carefully who's in control. One bit of warning. If your kids have never got along while you're alive, to say now, we'll make them together so they'll have to work it out. You might want to rethink that one. It doesn't normally work that way, just so you're aware. Last but not least, be aware that if you have a will is designed to go through probate. As a husband and wife, or husband, wife, as a married couple, you can have a form of a community property agreement, and at the first death, you won't need the will. Everything will go to the survivor. But at the second death, that's when there would be a probate. Now, we don't have time right now. If there are questions, we can talk about probates later. But understand, the probate process is a court oversight of the person usually that you designated, who will be in charge to collect all of your assets into an estate account, deal with beneficiaries, attorneys, creditors, and predators. When all that's done, address income taxes or estate taxes, and then give assets out to your beneficiaries. But it is a court oversight. It is public record. The time and the money to settle the estate will be after you die. It's as if you create with a will a little handbag, and the only thing you put in the handbag is your babysitter instructions. But when you die, if they go through the probate, they have to make the handbag into a full-blown suitcase so it can hold the assets and then carry out your babysitter instructions. That's what a will do for you. Let's look at living trusts. Things to remember about a living trust is that more people understand what a will does than what a living trust does. So even though we may spend more time right now on a living trust, that is in no way to say you should or you should not do a will or a trust. It's just it takes more time sometimes to explain what a living trust is. Also, if you have not met with us, we have a one-page wills versus trusts of the pluses and minuses to both. It is something that we would go through at those initial meetings that we do with our clients. If you would like that, you can email Allie, who you emailed to be a part of this seminar, and she would be able to get for you the wills versus trusts, pluses and minuses. Any attorney who tells you all of my clients do wills or all of my clients do trusts is doing you a disservice. The role of the estate planning attorney is to tell you what the tools do, not to tell you which tool you need. The challenge to you is to understand the tools and then match your goals and desires with those tools. So let's look at this last tool, revocable living trust. This is an entity that you create now, and rather than a little handbag, you create the big suitcase now. And yes, you put in your babysitter instructions. And then yes, you work with the trustee, with your attorney to make sure that assets are in the name or beneficiary to people or the trust. You are spending more time and more money to put something in place now so it doesn't have to go through probate at your death. That's why there's no right or wrong. It is what are your goals? What is the tool you'd like to see happen? You are going to put who's in charge. And if you're competent, you should put yourself in charge. It's yours. It's your social security number. Doesn't change how you do your tax return. You can choose the beneficiary. You can choose how they get it. Just like you do in a will, the babysitter instructions are the same. In a trust, you appoint your successor who is a trustee. In the will, it was the personal representative. You still have the same 4 categories: immediate family, extended family, best friends, professionals. You have to choose who. One of the concerns about people is going forward, how do I maintain a trust? Well, a big part of maintaining the trust is making sure you do meet with the attorney, with the CPA, with the financial planner on a regular basis, every 3 or 4 years, 4 to 5 years, and make sure that your beneficiary designations are all still incorporated. We're working with a client right now with their trust, and their institution where their financial investments are has just been bought out. And all their investments are now to move over to the new institution. So the very first thing we're talking with them about is make sure at the new institution they carried over your beneficiary designations, the titling on the accounts. All of those things are very, very important when you are doing a revocable living trust. A couple other things to keep in mind with a revocable living trust. One, the trust itself has protections from probate, and if you are not concerned about Medicaid, then a revocable living trust also has protections against a court-appointed guardianship. If you want to do Medicaid planning, a revocable living trust is not usually the best tool to use between husbands and wives. So if you're trying to do Medicaid planning, you may need to use a different tool. But if that's not your concern, but it is probate or privacy or get the work done so they don't have to do it later, and you're not afraid of doing the time and the money now, then maybe a living trust is for you. That comes out in that initial meeting. If you are looking to do Medicaid planning for your parents, for yourself, it is very important that you take the time to meet with a Medicaid, an elder law attorney. We don't have one on staff anymore. Jericho is great. She's still a referral source, but we do have a referral source to 3 different attorneys who do Medicaid planning in different parts of the city. So be aware, if you are doing Medicaid planning, your primary tool will probably not be the living trust. Another thing we've touched on briefly is there are 3 roles in a living trust. The trustor, that's the creator. The trustee, that's the manager. And the beneficiary, that's the one who gets to enjoy it. If this is your living trust, you get to do all 3. Okay? I do want to briefly address estate taxes in just a word. We have another seminar we've done on that. If you have more questions, we can answer those another time. You can do estate tax planning in both a will and a living trust. So you're not limited, in spite of what some institutions have told you. You can do it in both. So just make sure you are aware that you have that opportunity. Now, Mark has a great quote here. If it weren't for the last minute, nothing would get done. Another quote that you'll see on my business card is, check in before you check out. Anything you can do while you're alive will be more helpful than after you're dead and someone else trying to do it for you. So we have a couple of questions now. Mark, I'm not sure if you're going to come back. Hi, Mark.
Hello. All right. Well, thank you, Ryan, very much for that review. And we've got a number of questions. First of all, I did talk to our IT guru here, and she said that we could probably get this seminar up maybe by early next week. So she has to do some editing. She's got to give me a little bit more hair, fill in some of the wrinkles. But other than that, I think the seminar will be good to go. We also have a question on, in addition to having a living trust done, do we need to buy funeral plans from a funeral company such as Neptune Society? We do have a number of clients that will do that. Generally speaking, it's not a bad idea at all to pre-plan, especially right now. Many people don't realize that when someone dies, especially if they're at the hospital typically wants to have the family claim the body or have a place to put that, to bring the body within a very short time, typically within maybe 24 hours. So having those arrangements in place can be a very good thing. The binder materials that we have, you're giving your instructions. But if you do have those kinds of notes, or you already have any kind of burial or funeral arrangements, then you can at least let others know. And that way they will be looking for the paperwork to make sure that everything goes smoothly. All right, so the next question, should I wish to come in and see you regarding a trust set up by you, what is your hourly fee? Ryan, what's your common response to that?
My common response is, I would love for you to come in and do a review. Again, the times we encourage review is life events, birth, marriage or divorce, death. If none of those have occurred recently, you should come in every 4 to 6 years. And for one of our clients coming in to do a review of their estate planning, we don't charge for that. Everybody is better off if it works. When you do come in, always bring your notebook.
Right.
Because if you're going to update things, we want to make sure we update the notebook, as Mark mentioned earlier, and make sure new stuff might be in there, certainly if it's new documents. So we don't do an hourly fee. I actually don't even really keep track of what my hourly fee is, so I can't even quote that to you. But you do want to set aside 2 hours. It should be done in an hour, but in case we get to big questions. If you're going to review your trust, please remember, review your powers of attorney as well. It may very well be that who you appointed in your trust is also in your will, in your financial power of attorney, and maybe even in the healthcare, all of which might need to be addressed.
Thank you. So the bottom line is that no, there is no hourly fee. We'll meet for a couple hours, and then at the end of that discussion, say, here's what you wanted, here are the documents, here's how you wanted things to be, here's the fee quote, and you can decide whether you'd like to move forward or not. The next question, can a guardian or surrogate be retained to care for those solo elders in senior homes? Richard, if you would email me your email address, there are some contacts that you may want to reach out to. Fidelta would be one, Andal Care or Comfort Keepers, and I can provide those referrals to you, because those kinds of senior care managers, that's kind of what they're focused on, and it sounds like that's really what you'd like to do. So if you see the email, contact at Rehberg Law, and I think my email address may be on here, but otherwise just send it to that, and then we will go ahead and make sure we send you those referrals. Next question is, having assets in the name of a revocable trust, are there other untitled assets that need to be specified? And the answer there is you will, and yes, it should be in your handy dandy notebook. There's going to be a section called the personal effects disposition. And that section would be in your notebook. And underneath that page, there'll be some blank pages. That's one of the pages you can fill in. So if there are particular items, as Ryan points out, these are things that aren't nailed down in the house or the garage, which I love that explanation. So jewelry, artwork, heirlooms, hey, even the Harley or the car, as long as they're not attached, probably a personal effect, you can specify certain things that you might like to go to certain people if they would fight over it. I had a client who had a 6.5 carat diamond ring, and she had 2 daughters, and I said, you're really going to have to decide which one gets it if you promised it. So those kinds of things, but many other things, your trust or your will have a general statement that says any of these things that don't have a title have been assigned to the trust or are going to be governed and carried forward under the trust to the people that you've named inside the trust or the will.
I would also add on there, if you do have multiple things you're going to put on your personal effects list, be very thorough. We've actually had people make a whole book out of this. Taking pictures is very helpful, and being clear. We had the responsibility and the privilege of settling an estate, and we saw the personal effects list, and the personal effects list said the blue vase on the fireplace mantle to a neighbor, the plate collection on the kitchen wall to another neighbor. We go to the house, we walk in, guess how many blue vases are on the mantle? 3. We go into the kitchen. I don't know about you, my kitchen has 4 walls. And sure enough, there were 4 different plate collections. Which one goes to the neighbor? So you want to be clear, not only with the diamond rings, you want to be clear, very clear. If you're going to use a personal effects list, if you can take a picture, that will help, but be very, very clear of what you're trying to do.
Yeah, great, thank you. Next question is, how long is the directive to physicians good for? Mine was signed 14 years ago. The law has really evolved in this area. There haven't been any large, giant legislative proposals or new statutes, but every year things get more carefully defined. What is a terminal illness? What is what's brain death? What does that mean? How do we certify that? How does a doctor say, is there really a medical hope or not? And then what descriptions do we have in terms of what you would like to have done? So I would say you probably at least want to have the directive to physicians looked at by an attorney, and they can look at it and say, you know what, the law and our documents have been very much more carefully defined than they were. Or they may say, it's not unheard of, where I'll look at someone's directive, usually not 14 years old, but maybe 5, 6, 8 years old, and I'll say, you know what, that seems fine right now. But you're probably going to want to have an attorney look at that. Next comment and question would be from a client who moved to Idaho. I just read recently that Boise, Idaho is one of Forbes' best cities to move to. Said we met with an attorney here, went over the Rehberg Law Group documents and gave us a thumbs up, but did say an Idaho healthcare directive to have for the registry there. She's wondering if dying in Idaho is going to create problems for our executor. Ryan, what do you think?
Well, that depends. This is definitely my area. The issue becomes not just you dying there, but how clear were the documents? Where does the person live who's going to be the executor or personal representative, and where are assets located? If in fact it is to happen in Washington that the probate occurs and your personal representative is in Idaho, there would need to be a resident agent within Washington for service. And most states, to my knowledge, do request that. So if the person in charge isn't in Idaho, then they may need some help from someone who is in Idaho to do that. So again, I don't know Idaho law. I can look at it only from the reverse.
Right. Generally speaking, if you move, it's good to do exactly as you've done, and that is have an attorney there take a look at everything and make sure it's not going to cause any problems down the road, which it sounds like you've done.
But Mark,
right.
Before you go on, I did notice that there were some people that are attending the seminar that had come up showing you've raised your hand. If you have raised your hand, we actually can't see that, but there is down at the bottom a place to do a chat. If you have raised your hand, I'm not ignoring you on purpose. I don't know you're there. Feel free to get on the chat and ask these questions. That'd be very, very helpful.
Right. Thank you. Thank you. Next question. Do you have a seminar regarding the steps the survivor should take upon the death of a spouse? For example, who do you call first, second? And the answer is yes. In fact, I believe there is one on our website, and that is under, we'll look in a couple pages. Waylon, could you scroll forward a couple pages? On the, yeah, thank you. So where it says https rehberglaw.com seminars, there's a number of different seminars, and I believe there was one done recently by Jim Davies and Sabrina Go. I think that one is there on that specific topic, but we typically do that seminar once or twice a year. So if you want to see a live seminar, that undoubtedly will be coming up soon.
Another comment on that is the first few weeks are friends, family, and funeral. Very, very seldom do you need to meet with an attorney immediately. There are exceptions, and that is when all the family is in town. And that's the case, we will do a meeting with you, but we will also normally set it up that it's sort of the end of the day or after hours. It has to be, because otherwise the schedule would be full. I will say that we do have a letter that we send out 2 to 5 a week, and only about a quarter of them are actually for our clients. So if you have lost a loved one, or if you have a friend that has lost a loved one, even if you're not a client of ours, have them or have you call us. The 3-part letter is: 1, how do you do an inventory of the people and the stuff? 2, this is the one people look for immediately. Where do I start? Because this is 4 pages of the most common institutions that might need a phone call. The 3rd is an overview letter that addresses settling of an estate. If you know, or the person who's calling us knows the type of estate planning, we have about 12 to 15 of these letters. Is it a will? Is it a trust? Is it there no estate planning? First death, second death, individual died. Is there estate tax planning? What type of estate tax planning? All of those warrant a different letter. We do not charge for those letters. Depending on the circumstance, there may be a 2-hour meeting you'd like to come to. Normally that meeting is $500. And that gives you an opportunity to ask all the questions you would like. But it really is based on getting the letter, taking the next few weeks, working through that, and then making sure you have a time to meet with an attorney. And it does not have to be the attorney that set up the estate planning. It does need to be someone who is very versed in helping people settle an estate plan.
Perfect, thank you. And yes, once again, I'm going to go back to the handy dandy notebook. You're going to see in the back, it has a section and it's called Things to Do When Death Occurs. And that indeed has a large checklist that is a start to that. Certainly it's better if you have something that's been done early or more recently, because then it's going to be more up to date. All right. So relative cost to convert will to trust is one of the questions. And here I have to tell my clients when they say, they ask me this, that we don't really have a trade-in value. So we can't take your old will and then put it out on our back lot and sell it to someone else. So it is a little different in that way. But the good news is, right, as Ryan explained before, we don't charge for the meeting. So you can come in and learn more about what are the benefits, what are the disadvantages of a living trust versus a will. At the end of that meeting, we'll give you a fee quote and say, you know, this is like what it would cost. And what we're trying to do when we do that is not just tell you, here's what the document is. What we're trying to do is give you the full solution to what is there. In other words, other documents you might need, ones that Ryan was talking about, or wills or community property agreements, powers of attorney, but also assistance with funding. That's one of the keys that Ryan mentioned when he was talking. Retitling assets, if you have a trust, is really critical. And we'll partner with our clients to do that at the very beginning, because we've seen too often attorneys who don't do that, and then the living trust doesn't work right. But that would be part of that meeting. So there's no particular harm to you other than learning more about a living trust and how it works. How does one find the best and most reasonable funeral burial plans? Ryan, I'll throw that to you since I said I'd give you all the hard ones.
Thank you. Time. It takes the time to call around. It takes time to shop. You want to have someone go with you. You don't want to do it on your own. You want to make sure that you write down the notes and get in writing from each of them what they're offering. It really becomes a personal preference as to what you like and where you would like to be, and whether you want to be cremated or any of the above. And before we go on to the next one, I do want to give a shout out to the person who asked that question. I will not say your name, but it was very good to hear that you were a part of this seminar. I hope you're doing well. This is a longtime friend of mine back into the 80s.
That's
and so
great.
I'd love to see.
All right, so then there's a comment just that we prepared will documents last month, so thank you very much. Then the next one, Ryan, there was a question regarding your example of the ring, right? What's community property? What is?
The reason I use that example of the ring is because there are amazing lawsuits over the wedding ring. And this is the original wedding ring that Sandy gave me. She gave it to me on our wedding day. She gave it to me before we said I do, which technically at that point in time we were married, which meant separate property is assets you bring into a marriage and you do not commingle. So this was my separate property that I brought into the marriage because it was a gift to me before I got married 34 and a half years ago. If, though, I were to add another diamond to it now, there's a little one for Sandy, by the way, for each of our boys, then I have no commingled it with community property. And now the ring is half of Sandy's. So the issue becomes when people in Washington get married later in life with separate sets of assets, what you bring into the marriage is not community property. You are bringing in separate property, and you really do need to talk with an estate planning attorney, a financial planner, to affirm what you intend to do with those assets.
Thank you. All right, the next question, is there a special form for HIPAA to allow medical professionals to talk to you? The answer is yes, there is some special language. The language that Ryan was referring in is in our power of attorney for financial matters. Basically, it says I'm releasing the doctors from liability if they're, they need to provide private medical information to my power of attorney, my agent. So that's in all of our powers of attorney documents, and our medical as well. We do have, for some clients, we'll also put together a HIPAA release form specifically for the family or others in case they're not part of the power of attorney, that chain of command that we talked about. But there really should be that in advance, because once I've literally had it where a wife came in and said, this happened to my husband and my insurance was paying for his care, and I went in without a power of attorney and the doctors said, well, we can't technically tell you anything. There's no HIPAA privacy release. That's a little on the far extreme side, what the doctors did in that case, but certainly having the power of attorney or the HIPAA release would have helped a lot. Can you explain about your son who was a child and why you don't let son inherit? So Ryan, I think this was another example.
Yeah, obviously you don't know my son. My son is 29. He is not married, and he has our grandson. And the reason why I would not give it outright to my son, if Sandy and I died right now, is it is his, which means it would go under his social security number. And even though if he gets married, it's considered separate property, he would have the right to commingle it. He'd have the right to give it away when he died. He'd have the right to do whatever he wants to with it, which means if he gets in a car accident, which he has done, that money is open to that lawsuit. If he were to get into a bad business deal and get sued, that inheritance is open to that lawsuit. If he gets divorced, that money is open to that divorce.
Mm-hmm.
If I want to protect the money to take care of my son, and if he dies, to take care of my grandson, then you use what's called a testamentary irrevocable trust. It goes inside your will or your living trust. And rather than outright, it's going to put a picket fence around that money. That picket fence, the money inside will have its own tax return, and it does not belong to Alex. It's there to take care of Alex, to take care of Caden. But if someone wants to sue Alex, they can't get in. If you want to marry Alex for my money, you can't do that. It's not his money. So not inheriting it outright is because of who my son is. We have people whose children are in a field that is highly sued. We have others whose children have very bad taste in a spouse, and they've been through multiple divorces. We have those who just don't have the same opinion of where they leave their money. Remember, it's your money. You get to choose who receives it next.
Thank you. All right, so the next question is, can I hire my own CPA when I'm hiring your firm as a party managing my trust? So we serve, especially Ryan has led the charge on many of our trusts, and if we're kind of trustee of last resort, I think is fair. Ryan talked about how, you want friends and family and you're looking to who those close ones are. But if you want more professional level attention, and there are a number of laws there, I don't think it's on our seminar site but Brian and I have done a seminar on trustees and the Trust Acts and the Son of Trust Act. And someday when he and I have more time, we'll describe to you kind of the the near, fisticuffs that happened at one of our seminars with the people who put that into place. But we will allow that, a CPA. We want to work with the people that you trust. So if you have a financial planner or you have a CPA and you say, these are the people that I, really want you to continue to work with, then subject to the fiduciary standards, of course, the trustee needs to do the right thing by your beneficiaries, then they would, work together with us. Ryan, do you have anything to add on that?
Yeah, we even have clients who really do want to recommend that CPA or financial planner be a part of the settlement of the estate. And we have even added that into the document, that the person setting up strongly recommends that this person will be used as the CPA, or this person will be used for investing assets. So you absolutely can do that. And we absolutely do that. It's again part of the three-legged stool. And if they're the ones who already know you and everything about you financially, absolutely they should be a part of the team.
Yeah, thank you. Okay, so the next question was just to make sure there was a slide, there was a bullet point that was missed. I believe, although I will have to then check with our guru on this, that you can download these slides, but if you don't have them and you'd like to have them, please send us an email. We're happy to send them to you. Okay, next question. Is there a way for a couple to request one of you to handle our estate after the last of us were to pass on? Yes, that would be putting us in as, we'd like you to serve in this way or this capacity, either as attorney for the estate or as the executor down the road, the personal representative. And you can certainly say, if my request would be that, Waylon Poland would serve as the, lead on this particular matter. None of us knows how long we're going to be on this earth, so it's usually not a great idea to put down, one particular attorney in terms of it must be so-and-so. But it's certainly, you could say, I'd like that to be my request, that they handle it. One of the things we're trying to do with younger attorneys who have, a lot longer of a career ahead of them, as us gray hairs, Ryan and I, sorry to do that to you, Ryan, we still have a long track ahead of us, we hope. But we are trying to plan for the future with the addition of Grace and Chester and Sabrina Go and Waylon. And they're kind of our own youth succession plan to make sure that we'll be here as a firm, for a long, long time to come. Ryan's dad started this firm 52 years ago, hard to believe. And it's continued on because the focus, the purpose was always to center us around a core group of values and ideals of trying to serve our clients to the best we can in an ethical and way with integrity and full disclosure on fees, and also make sure that the people we bring on next are part of that as well.
Mark, one other thought, and to the person who asked this question, just in case there's a different twist on how it was asked.
Yeah, thank you.
And that would be, if there's a husband and wife, if there is a couple, spousal, whichever way, can they choose different people? That answer is also yes. We have many cases where people choose different people to help settle their estate. Even if they have a combined estate, there's a way to designate one from each side to work together. So yes, you can have others be a part of that. Or yes, the Rehberg law firm would be a part of that in settling that estate. We currently are running about 156, 158 estate plans for people after someone has died right now. Because as Mark said, as a last resort, they wanted someone neutral, or they didn't have anybody they could trust. And we have the team and the staff to be able to do that for our clients if they choose to.
Thank you. And they've asked then a follow-up question. How would the cost be handled?
It would depend on whether it's a will or a trust. It also depends on how long it's going to go. We actually do have a fee schedule. It's on our website, but that is also affected by whether we're doing a probate or a living trust, and it's going to be all distributed out outright, or if it is something to be held into trust for many years. So it's hard to specify without being able to sit with you and talk about that, but we would be able to apply it directly to you if that were the case.
Thank you. Okay, the next question is, why do we need to sign the HIPAA disclosure permission on the post or the post form when we've got these attorney prepared documents and you provided it to the healthcare provider? I think each healthcare provider is going to want its own forms. They, want that kind of assurance that they have. This is the document that they're used to and they use. In most cases, certainly the post form is for a slightly different purpose than your healthcare power of attorney or your directive to physicians. The physician's orders for life-sustaining treatment has a lot more of those kinds of yes, no answers, like, do you want CPR? Or you want a blood transfusion? Whereas the healthcare power of attorney that we provide and the directive to physicians, those things tend to allow your agent, if you're not able to make the decisions, a lot more control, a lot more ability to see through the gray areas and to try to make the best call at that time. Ryan, any thoughts on that?
Yes, we very much do recommend the post form.
Mm-hmm.
It is a very good tool if you will collapse at your house and it's not with a fire. Because what it's designed to do is that a medic, by state law, has certain things they are to do when they come across you if you're unconscious. And it is only the post that can change that as the paramedic shows up.
Mm-hmm.
And so a post form done very thoroughly with your doctor is an additional document that is very helpful.
Thank you. Okay, and then another thought that was added is if a pastor of the church is asked to be the executor, then, and they want to leave some funds to I assume the church, would it be okay for the pastor to serve in that capacity, or is it a conflict of interest?
Yeah, that one is always fun. I do not see it as a conflict of interest because remember, I was a youth pastor at one time. The issue really becomes talk to the person. Ask that person whether or not. We have many times have had people ask for their financial planner to be the person in charge after they die, and then they come to find out that the institution won't even let them do it. They call it a conflict of interest.
Right.
But if your pastor, you've asked the pastor specifically as your friend to be the one in charge, that's not a problem. If in fact they are serving in the position, they do get to get paid. So if you want to leave them money, do not do it in lieu of what they would get for doing the job. It would be over and above just because you want to give it to them.
Thank you. And I would say here it'd be really important to make sure that provision giving money to the church is carefully drafted, because you don't want to leave any kind of discretion to the pastor to make some decision that other people could say, oh, well, you're just choosing to make that decision because. As long as the document is really clearly drafted, the pastor's just carrying out your instructions, then that really removes that concern, I think, about the legal conflict of interest. Okay, so Waylon, if you'd go back to that last slide. So here's kind of those resources. Let's just talk about them briefly. We've already talked about the seminars, and we do have a resources menu. So after this seminar, it's not a bad idea to go on to our website and just start looking around. That'll give you a lot of different places and a lot of resources to look to, not least of which are some of our older seminars on things like what happens after a loved one dies, or other kinds of seminars we've done. There's a couple books as well. I believe these are both available on King County and with Seattle Library. And I think if memory serves, they are also available on Overdrive. So you can get these electronically. And this gives you a good, pretty well-written summary or overview. They are a bit dated, of course. By the time anything is published, it's already out of date, and they're probably a few years old, but they'll give you some of the basics as well. And then finally, I mentioned the What to Do When a Loved One Dies, if you would like, and it's been a while since you've come and visited us, we can go ahead and give you that particular sheet that had that sort of initial checklist, and we can send that to you, kind of a PDF scan of that. If you want to email to us, we want to make sure that we're a resource available to you right now, so that you could then print that out, take a look at it, add it to your binder. If you've been to see us in the last few years, you probably have a pretty updated one, but if it's been longer than that, it probably would be a good idea to update that. All right, so that seems to be the questions, and wow, those were some fantastic questions, everybody. So thank you very, very much.